And I'm just going to say a few words and then turn it over to Sarah and Lori. So thank you all for joining our webinar this evening about newly elected officials and what you need to know. Congratulations on the new position you've just taken. And if you're already a sitting official here for a refresher, thanks for joining us. Topics that will be covered tonight include conflicts of interest, codes of ethics and boards of ethics, financial disclosure requirements, typical town offices and their roles, oath of office, and preparing for your first meeting. There will be plenty of time for questions and answers. Please put any of your questions in the chat and we will be addressing them as we can during the webinar. And this webinar is sponsored by the Tug Hill Commission in conjunction with the region's 5 councils of government. My name is Katie Malinowski, and I'm the Executive Director of the Tug Hill Commission. For those of you who may not know, the Tug Hill region covers 2,100 square miles in portions of Jefferson, Lewis, Oneida, and Oswego counties. The Commission is a small, non-regulatory New York State agency that provides technical assistance in the program areas of land use planning, local governance, community and economic development, and natural resources management. So with that, tonight's presenters are Sarah Brancatella and Lori Mithen-DeMasi, two accomplished attorneys from the Association of Towns. Sarah is AOT's Deputy Director and Lori is AOT's General Counsel, I believe. And with that, I'm going to turn off my video and turn the mic over to them. Thank you.
Thanks, Katie. Really, again, just wanted to emphasize thanking Katie and thanking the Tug Hill Commission for having us tonight. We love working with the Tug Hill Commission. They are such a tremendous resource for municipalities, and the Tug Hill region is genuinely such a unique and special region. I always love attending their local government conference in, I believe it's April this year. Highly recommend that. But if you are a member of a town, please consider NIOT a resource for you. If you are a member of a village or a city, NICOM is the equivalent to NIOT. They provide services for cities and villages, an equally wonderful organization. So tonight we are going to get started with a welcome to town government, which is a very broad overview of the types of services that town governments provide. And some of you, as Katie had mentioned, might have previous experience in town government or in local government. So there's no real standard literacy, local government literacy level, let's say, with town government. So we're going to start tonight with a very high level, broad overview of what is a town, what kind of services do local governments provide, how they're provided, how they're funded, and what departments provide those services. Without further ado, I'm going to turn it over to Lori to answer the non-existential legal answer of what is a town.
Thanks, Sarah. Okay, so for folks who are not familiar with local government, a town is a general purpose local government. What that essentially means is that towns have the authority to provide services, to legislate, to regulate the conduct of others, and to generate revenue, primarily through the property tax, to fund those services. It's a statutory definition, also a constitutional definition. And there are other local governments that fall within this category. Those include counties, cities, and villages. There is some overlap by design. All general purpose local governments are included within a county, and all villages are included within a town. Villages used to be the population centers of the towns. The towns were primarily farming areas located outside of the villages, the population centers. Towns are primarily created by the state legislature, although there is a procedure for a town to create itself. Villages are primarily created by the residents within a population center of a town. And so, as the kids like to say, we'll get you started with a few fun facts about local governments. So about 42% of towns have one or more villages within their boundaries. 12% of villages span 2 or more towns, and 1% of villages span 3 or more towns. Um, Towns can range in population and territory. As an example, the largest town in the country actually, is located in Nassau County. That's the town of Hempstead, with a population just under 800,000. The smallest town in the state of New York is the town of Red House in Cattaraugus County on the other end of the state, and they have a population of 30 by the latest federal census. Territories can differ for towns. The town of Webb in Herkimer County is the largest town by territory. They have just over 452 square miles. And that's larger than several counties in the state of New York by territory. The smallest town by territory is located in Albany County, and that's the town of Green Island, and they have just 1 square mile. So, regardless of your population or the geographical size of your town, towns all provide very similar services. Next slide, Sarah. So to make it a little bit easier for our towns to provide these services, the state of New York has created 3 classes of towns. Sarah's going to talk about home rule, I think, or maybe no. Well, home rule is a very important aspect of local government authority, and it gives towns the opportunity to create the programs that they need and provide services in the manner in which they can do so most appropriately for their community. So you've
And
got
also, sorry, just going to interrupt, Lori, and also
Sure.
villages have home rule authority as well.
Yes, they do, and cities and counties. We all have it. Yes, we do. It's under the Municipal Home Rule Law and Article 9 of the New York State Constitution. So the reason that we bring up home rule is because it does allow, regardless of your classification, the opportunity to provide services that your town residents need. So the majority of towns are in what are called the town of the second class. About 12% of towns are in the town of the first class, and then a subset of the first class towns are suburban class towns, and that's about 6%. Roughly speaking, with some limited exceptions, if you have a population of less than 10,000, you're going to fall within a town of the second class. More than 10,000 or more, you're going to fall within a classification of first class. And again, the main distinctions here are the way that we provide services, but those can be changed by the adoption of a local law. What kind of services do towns provide? This is just an example. Towns provide a variety of services, some of which are required, some of which are optional, some of which are classified as essential, but all of which are important. So your required services include things like maintaining roads and bridges, providing town justice courts and dog control services. Some optional services might include the provision of water, sewer, or parks, planning and zoning, and recreation. Some essential services that towns provide include public safety, code enforcement, and as I had said, these are all important services, and the manner in which we provide them may be different. And you may provide some of these, or you may provide all of these, or you may provide additional services that are not referenced. I had mentioned the importance of villages, and this comes into play when we're talking about the provision of services and how those services are taxed and funded. So most services are going to be provided town-wide. If you don't have a village within the boundary of your town, all of your services are primarily going to be provided town-wide, except for those that are provided via special improvement district. If you've got a village, one or more village within your town, some of your services are going to be provided outside of the village, or what's referred to as part town. In accounting speak, this would be townwide would be your A fund services, and part town or town outside village would be your B fund services. In addition to which, we've got the authority to provide services at the town level through special improvement districts. This is an important tool available to towns to tailor the services that specific residents or constituents might request or need. These are found in the town law, primarily in section 198. If you're interested in the full laundry list of services that can be provided via special districts. Some commonly include water, sewer, parks, lighting. Fire protection can also be provided via a district. It can be a fire protection district, which is primarily managed by the town board, or it could be a single purpose local governmental entity known as a fire district, which is governed by a separately elected Board of Fire District Commissioners. According to a recent count, there's just under 8,000 special town improvement districts located in the state of New York. That number changes all the time, though, depending upon the needs of a particular constituency. And now Sarah's going to talk to us about how we fund these very important services. Sarah, you're muted.
I just realized that. Yes. Okay. So obviously we have to get money to pay for the services. One of the main sources of funding, actually the main source of funding for town services would be through the real property tax system. Lori's going to go a little bit more in depth on that, but that is overwhelmingly and primarily the source of money for towns to fund their services. Obviously, this is problematic. Some of you may live in communities where a majority of your property is tax exempt. That is a product of state legislation. There are issues with it. It's an imperfect system, but overwhelmingly for most towns, your funding comes from real property taxes. Also important, especially this time of year, is state aid. Last week, the executive budget was released. That's the governor's budget. It has contained within it certain funding sources like AIM, the aid and incentives for municipalities. That's general purpose revenue sharing. So towns, villages are able to use that money for whatever they want. It is distributed pursuant to a formula. Again, there are no strings attached to it. Another main source of state funding would be CHIPS, the Consolidated Highway Improvement Program. I forget what the S stands for, but CHIPS is very important for towns and villages. It helps you maintain your road system. Again, you don't have to apply for that. It's just something that your municipality will get automatically. The executive budget is just the first step in the state budget process. If you are interested in learning more about the state budget, NIOT has a quick little video on what's involved in the state budget process, but ultimately the state budget isn't going to be adopted until April, sometimes May, but the process kicked off last week. So pay particular attention to what is in AIM and CHIPS. Otherwise, most state funding is through grant programs. So yeah, we rely on state funding to fund some of our local government services. There are also fees and rents that municipalities are able to charge. For example, there are fees that you're able to charge for dog licenses or building permits, things like that. And then there are miscellaneous things like sales tax. Sales tax, towns and villages do not have the authority to impose independently. It can be imposed by cities and counties. Most counties have sales tax sharing agreements with municipalities within their jurisdiction. If you're not familiar with how much sales tax your county might share with you, just go back, take a look, see what the sales tax sharing agreement says. That being said, counties are not required to share sales tax with municipalities. I believe it's 13 counties in the state don't actually share sales tax. Nonetheless, it's a source of funding that is an optional provision for local governments to provide their services. With respect to towns and actually with respect to villages as well, you can generally classify, moving on from funding and going into more of like the personnel aspect, you can generally classify anybody who works for the town into one of three different types of positions. One would be elected officers. Obviously, those are individuals who are elected to office. Quick little note about that is If you appoint somebody to an elected office, for example, let's say that there is a vacancy that exists in the position of town supervisor, and you appoint somebody to that position, it doesn't make it an appointed position. It's still an elected position. You are just appointing somebody to that elected position. So there are elected positions, there are appointed positions. In terms of town parlance, that would be positions like your planning board, zoning board of appeals, deputies. And then there are positions that we like to think of as your traditional employees, highway laborers, seasonal employees. It's important to think about the differences. Like, we classify these in 3 different groups for a specific reason, because the way that the law intersects with those positions are different. The best example of that would be through, if we're looking at termination. For example, if you are not allowed to fire an elected officer, the policy behind the law is that an elected officer is answerable to the electorate that voted them in. The only way to get rid of somebody who is in an elected position is to bring a court proceeding. Comparatively, for appointed positions, it's not a one size fits all, but there are specific procedures in law, for example, to remove somebody from a planning board in a town or from a zoning board of appeals in a town. So you don't have to go to court for all appointed positions. There might be different processes, but there's not as much job protection for an appointed office as there is for an elected office, generally speaking. And then traditional employees, there we get into a situation where you interact with potentially civil service and civil service protections, or otherwise, New York is an at-will state, meaning unless you are provided civil service protections, then you are an at-will employee and can be hired and fired at will. Whereas for an appointed office or an elected office, there are different procedures. A really broad bird's eye view of the administrative structure of a town and local government is all about relationships. This is regardless of whether you are in a town, city, village, county, every single level. Local government is about relationships and understanding the authority that your position has in relation to another position. So for the towns, this is a very bird's eye view. We are going to go through each wheel spoke, if you will, but you might notice that town boards are at the center of it all, and that's where we're going to get started. Unlike a mayor in a city or a village, there is no real CEO in a town. The town board acts as a body. They are the center of things. If you have a 5-member town board, you need 3 people on that 5-member board, a majority, a quorum, to get anything done. A supervisor on a town board is an equal member of the town board, but their vote, for example, doesn't carry any more weight. They have no authority to act on their own, act unilaterally, unless a statute says that they can. I like to think of it as, and this is definitely providing a specific age range that I'm in, but in the early aughts, in the early 2000s, there were the Spider-Man movies that came out with Tobey Maguire. And there was a line that was said over and over again in those movies that were like, with great power comes great responsibility. And when I started doing work in the local government context, I always thought to myself with the supervisor, well, there's more responsibility, but not really more power. So yeah, the supervisor is really, unless a statute says the supervisor has more authority, the supervisor is just another member of the town board who also has additional statutory responsibilities. The town board does have the ability to delegate day-to-day responsibilities to the supervisor. That's just, you can't delegate any sort of statutory responsibilities that the town board has, but it's more a situation of you need to keep the trains running on time, right? You need to keep the town functional. We understand that town board members might not be there every day, but the supervisor might be there every day. So the town board does have the authority to delegate day-to-day administrative tasks to the supervisor. If we go back to grammar school and thinking about the division of government between kind of the executive, legislative, and judicial branch, the town board is the judicial branch, and they have the authority to adopt local laws. That is one of the primary functions of a town board. They also have the authority over administration of town affairs. That means control over finances. The town board is the one that adopts the budget. The town board is the one that has authority over town property. You are the one that audits claims, approves purchases. Generally speaking, Lori's going to go over some of the exceptions, but generally speaking, you are the ones who appoint officers and employees. There are, again, some significant exceptions to that rule. For example, a deputy town clerk has the authority to appoint their deputy. Lori's going to go into more of the highway aspect of that. Other major administrative functions that the town board serves is setting salaries, setting employment policies, determination of benefits, what class of employees gets benefits, if any. And then Lori had mentioned special improvement districts. And a few administrations ago, in the governor's office, there was a line that came out that said that there were 10,000 units of local government, and that was way too many. That was including special improvement districts. Lori had mentioned that there are about 8,000 special improvement districts, but a vast majority of those are governed by your town board. There is not a unique separate entity to govern those, but for asterisk fire districts, which are governed by fire commissioners. But overwhelmingly, special improvement districts are created and administered, governed by your town board. Fiscal administration is one of the major responsibilities of town board, and you have the authority to designate your bank depository, create investment policies, approve the budget, approve and create the budget, approve budget transfers, and then a major responsibility is to approve all contracts and audit all claims. Going back to how that interacts with the supervisor, again, the supervisor is not sitting there with any more authority. The supervisor has no authority to say, yes, we are going to approve that contract. No, we're not going to. That's a determination of a majority of the board. Nonetheless, the supervisor does have more responsibilities with respect to fiscal administration. They are responsible by statute for the custody and care of town funds. So there is a monthly report, for example, that supervisors have to provide. And that's also related to they are responsible for dispersing all monies, actually signing contracts. They're not responsible. The town board is the one that approves contracts, determines that a town is going to enter into a contract, but the supervisor is responsible for actually signing and executing the contract. And they are responsible for keeping accurate books. As I mentioned, a supervisor does have a monthly financial report responsibility. With that, I'm going to turn this over to Lori to talk a little bit about the real property tax cycle.
So Sarah had mentioned the administration of town funds and the importance of town funds in providing a revenue source for our operations, our salaries, our services. Most of that money comes from the property tax, and there are different players associated with the property tax. This on your screen is just a very basic overview of the real property tax and collection cycle. It begins with the assessor who will value your real property within the state of New York, within your towns. That's generally speaking done by the taxable status date. And then we moved to the development of the assessment roll, which is the value of the property. The tentative assessment roll is roughly due around May 1st in most jurisdictions. And if an individual is not happy with how the assessor has determined the value of their property, they can try and sit down and discuss it with the assessor. If that's not fruitful, they can go to what's called the Board of Assessment Review. They have a grievance day, which is like a hearing where people who own property can come and argue that their property has not been properly assessed. This usually happens on the fourth Tuesday in May, although if your town shares an assessor with more than one jurisdiction, you may have changed that assessment date because the assessor is required to be on hand in the event questions arise. As Sarah mentioned, the town board will adopt the budget. That usually is in the fall before the start of the fiscal year in which that budget's going to apply to. So if you're newly elected, you just inherited your 2026 town budget from the town board that was busy at work in September, October, November, and perhaps December, depending upon where you're located, adopting that budget. And then how do we get the money? You're going to do that through the property tax collector. So next slide, please. So just a little bit deeper dive into the assessing players. We've got two main players in the scheme of assessing. That is the assessors. They can be elected or appointed. Primarily, they're going to be appointed in the state of New York, but there are some municipalities that still have elected assessors. If you've got an elected assessor, it could be a single or sole elected assessor, or it could be a board of 3 elected assessors. But again, overwhelmingly, most municipalities now have a sole appointed assessor. In fact, if you were a town of the first class, you were required to change to a sole appointed assessor in, I think, sometime in the 1970s. The sole appointed assessor has a statutory uniform 6-year term. They were just reappointed in October for a new 6-year term. So your prior town boards would have been busy doing that in the spring and the fall, interviewing folks who were interested in that position. And then, as I had said before, the other player in this space is the Board of Assessment Review. This is a body also appointed by your town board. They're a statutory body. They are required if you provide assessing services. And again, most towns in New York State provide assessing services. There are 2 counties of which I'm aware where assessing services have been transferred to the county. That's Tompkins and Nassau. But by and large, towns are responsible for assessing. So you're going to do that through either your own assessor or through a cooperative assessing model with another municipality or numerous municipalities. And then to give property taxpayers relief from the work of the assessor, and it is the assessor who assesses our property. It is not the town board. It is the assessor. You have the Board of Assessment Review. These members are appointed by the town board. They serve a 5-year statutory term. The Board of Assessment Review can be as few as 3 and as many as 5. They do have to have training and education, as do the assessors. And their primary responsibility is to hear complaints on grievance day and to adjust a property owner's assessment if necessary. If you need to go beyond that, you can. There are court proceedings that are also available after the Board of Assessment Review process if a property owner feels that it is necessary to continue on in grieving their assessment. Next slide, Sarah. So the last party in our tax and assessing process is the tax collecting officer. In the town space, taxes can be collected by one of the individuals on your screen: a tax collector, a receiver of taxes, or town clerks. If you are a town of the second class, you probably have a tax collector. If you are a town of the first class, you probably have a receiver of taxes. Towns do have the option to abolish the position of tax collector or receiver and to consolidate the tax collection services into the town clerk. This can be done either by resolution if it's a tax collector under Town Law Section 36, or by local law if it's a receiver of taxes under the Municipal Home Rule Law. And so only the tax collecting officer or their duly designated deputies, each tax collecting officer does have the authority to appoint a deputy, can collect taxes. So if you're at a town board meeting and somebody comes up to you and says, geez, I'd love to pay my property taxes, here's my tax payment, and you're the supervisor or you're a town board member, do not accept the payment of that tax. You do not have the authority to collect taxes. Only the tax collecting officer has the authority to collect taxes, or the deputy tax collecting officer if there is one in your town. The manner in which they get the authority is called the warrant, and this comes from the county. It is generally speaking for town and county tax collection season provided by December 31st. Taxes are generally speaking collected between the months of January and April. Town taxes are paid first, and then county taxes are paid after the town taxes are collected and received. Now, Sarah's going to talk to us about another important service that towns can offer, and that's planning and zoning.
So land use regulation is one of the fundamental core services that towns and villages provide. And you have the authority to do things like regulate the site, density and size of buildings and development in your community. I think more than any other area of town governance, planning and zoning really highlights the interdependency of relationships that exist. We could go on for an entire conference about planning and zoning, and in fact, we do have our own planning and zoning school that takes place in fall. Yeah, in fall and September and October. So this is, again, really just like a high level overview, understanding kind of like the basics. But you've got your town board that sets the policy, right? The town board, again, is the legislative body that establishes the land use regulations. Also, a really important document in land use is referred to as your comprehensive plan. I like to think of that as, or I refer to it as your vision board for how your municipality is going to develop. It's a really, really important document because you cannot have a local law that is adopted on land use that is contrary to your comprehensive plan. For example, you cannot have a comprehensive plan saying that you prioritize open space and then adopt a bunch of local laws that really prioritize development, right? We want to make sure that your local laws are aligned with your vision for how your community is going to develop. The town board is also responsible for appointing individuals to the planning and zoning board and the enforcement officer. If you're a municipality that has zoning, then you are required to have a zoning board of appeals. ZBAs have statutory responsibilities, meaning that state law says these are the things that ZBAs do. Specifically, state law says that ZBAs are responsible for variances and interpretations. Planning boards, by comparison, do not have any specific statutory responsibilities. In fact, towns are not required to have planning boards. They are created by the town board, and the planning board only has the authority that the town board says the planning board has. There's nothing inherent in state law that says planning boards do X, Y, and Z. Again, compare that to your ZBA, where state law says ZBAs do variances and interpretations. Nonetheless, some common responsibilities that are given to planning boards include helping to prepare and giving advisory recommendations on the comprehensive plan, actually having authority for determination on special use permits, site plan review, and subdivision review. Nonetheless, if you don't have a planning board in your town and you're like, wait a second, we still do things like issue subdivision review or provide special use permits, that might be a responsibility that's delegated to the town board or actually even the ZBA. There's no one size fits all. The only real tried and true rules are that ZBAs are specifically responsible for variances and interpretations. Then, of course, you've got your boots on the ground, right? The code enforcement officer who goes around and enforces not only a town's zoning code, but codes in general. Although oftentimes it's related to land use. So your code enforcement officer, as I said, boots on the ground. They are the ones that issue your permits. They are not responsible for interpreting the law. And I will say this until I am blue in the face. If there is a situation where your code enforcement officer thinks to him or herself, I'm not sure how to apply this law, the default should be they deny it. They're not in the position of interpreting law. And then that would go to the ZBA that does have the responsibility to interpret the law. But if you are in a municipality where you are regularly getting requests to interpret your code, if you're on the town board, if you're a village trustee, this sounds really harsh, but you're just not writing local laws well enough. You do not need to have a lot of heretofores, complicated clauses. Keep it simple. Your local code should not require an interpreter. You don't need the Rosetta Stone. The best local laws are those that anybody can read and understand what the town or municipality is trying to accomplish. I'm going to turn this over to Lori to talk a little bit more now about highway administration.
Thanks, Sarah. Okay, so we've got a lot of infrastructure in towns. A lot of that involves transportation, getting from A to Z and doing so safely. Towns manage the majority of roads in the state of New York. And to do that, we have an administration that we have to have in place in order to properly manage our road system. And that starts with the highway superintendent. The highway superintendent is primarily an elected office, but in some cases, the towns have converted that position to an appointed office. Regardless of whether the highway superintendent is elected or appointed, they have the same authority under the highway law, which is another general state statute. As an aside, if you don't have hard copies of New York State statutes, they are available for free on a variety of websites. One we commonly use here at NIOT is the New York State Senate. They have the consolidated laws, which are your town law, general, municipal law, municipal home rule law, highway law, different statutes that might come into play when you're talking about authority, and responsibilities. So the highway superintendent, whether elected or appointed, has jurisdiction over highway infrastructure and the highway department. But as Sarah said, relationships are really important, and there is some overlap here with respect to the town board and their jurisdiction with respect to highway operations. So under the highway law, section 140, the highway superintendent is primarily responsible for the repair and maintenance of town highways. We've had quite a bit of weather lately, a lot of snow plowing going on lately, and probably more will go on throughout the winter. They are responsible for snow and ice removal. They are responsible for highway machinery and equipment, and then employees who are on the road crew. They are responsible for all of those things, and they do so in accordance with various policies and budgetary provisions that are adopted by the town board. So as an example, talking about relationships and the space of employees, there is some overlap here. While the highway superintendent has the statutory authority to hire, manage, suspend, and if necessary, terminate employees on the road crew, the town board has the authority to create those positions, to fund those positions, to adopt the employment policies such as compensation, benefits, collective bargaining agreements, if you've got a unionized workforce, are approved by the town board. So the highway superintendent has statutory authority to manage the employees, but must do so in accordance with the policies, generally speaking, that have been adopted by the town board or negotiated by the union, if you have a unionized workforce in your highway department. Another area of overlap would be funding. Sarah talked about this a little bit and during the funding slides. The town board adopts the budget. That includes money available for highway operations. Typically, that money is divided into 4 buckets from your repair and improvements, bridges, equipment and machinery, and then snow and miscellaneous. And if you've got a village, some of those are funded town-wide, some are funded town outside village, and some your town board has the authority to determine if you want to tax village taxpayers or exempt them from those funds. But it is the town board that puts together the funding plan in the budget for highway operations. Where that money is spent is outlined or negotiated between the highway superintendent and the town board. That's your annual paving plan, commonly referred to as the 284 agreement. It's called the 284 agreement because the requirement to have this paving plan is set forth in Highway Law Section 284. You cannot spend money on repairs and improvements of town highways unless you've got an agreed to 284 plan in place. So it's important to do that as early in the calendar year as you can, so your highway superintendent can put together a road improvement program based upon that agreement that is entered into by the town board and the highway superintendent, and can buy the materials that are necessary or enter into contracts that might be necessary to accomplish this task. We have sample 284 agreements if you don't have one and you'd like a copy of one, or we provide a variety of manuals for town officers to help them with their responsibilities. For highway superintendents, it's colloquially referred to as the Red Book. There is a discussion about the importance of the 284 agreement in that book, including a sample 284 agreement plan. We also co-sponsor in the spring a large highway school with Cornell Local Roads. Cornell Local Roads is a program that's been around for decades. They have a contract with the state of New York to provide training and services for municipal highway departments. And we co-sponsor with them a large highway school, which is held at Ithaca College in the first week of June. You don't have to be a highway superintendent or highway official to attend. It's a great idea for supervisors and town board members to also attend at least once so you can get an idea of what your highway superintendents need to do, can do, and how they can do it. Next slide, please. So we're talking next, I'm sorry, there's a question here. What are those what were those 4 sections of the highway money? Okay, so you want to take a look at Highway Law Section 141. That lays out your highway fund. It includes 4 items, roughly referred to as items 1, 2, 3, and 4. Item 1 would be repairs and improvements. Item 2 would be bridges. Item 3 would be equipment, miscellaneous, tools, implements, things of that nature. And item 4 would be snow removal and miscellaneous. Miscellaneous could be things like removing brush. You're responsible for cleaning drainage ditches, things of that nature. That typically happens in the spring, but it's all outlined in Highway Law Section 141. Permits and licenses. Every town, this is issues permits and licenses. Some are required to be issued. And some are authorized to be issued depending upon what your town has adopted. So for permits and licenses that are required to be issued, your town clerk is going to be actively involved in this process. Some that the town clerk will issue would include marriage licenses, going out of business licenses, dog licenses. Some town clerks also issue hunting and fishing licenses, which are regulated by the Department of Environmental Conservation. Maybe you regulate locally junk dealers. That's something that you could choose to do. Or you might have event permits that are required if somebody's going to be holding a large event in your community. So you can have some that are locally required and some that are state required. A common example of a state required license would be the marriage license. Your town clerk is the officer who is required under another state statute called the Domestic Relations Law to issue marriage licenses. In keeping with marriage licenses, that's part of the vital records universe, and there are other vital records issued not by the town clerk, but by the registrar of vital statistics. Those include birth, death, and burial permits. Those are outlined in the public health law, another state statute, all of which come under the jurisdiction of the New York State Department of Health. They provide training and information on how they want these things done. And they have something that they call the Blue Book for registrars of vital statistics. Registrars of vital statistics are primarily going to be appointed by your town board in the town context. And it can be the town clerk, but it also can be somebody else if you've got a particularly busy town clerk's office, or you've got a particularly busy vital records area. Maybe you've got a nursing home and it requires a full-time person who can devote all their resources to being the registrar of vital statistics. Sarah touched upon the importance of building permits. Those are issued by your code enforcement officer, and that's a service that towns provide unless they have transferred that service to the county, which they have the authority to do under another state statute called the executive law. Lots of statutory references tonight. Sarah, next slide, please. So we generate a lot of paper, a lot of records. Records are broadly defined. They can be paper records, they can be electronic records, anything that houses information, whether it's video, audio, written, that's going to be considered a record. Records come into two basic categories in the town setting. Records can be made available to the public through something called the Freedom of Information Law. That's housed in another state statute called the Public Officers Law. There is a state agency, called the Committee on Open Government, which provides training and education and lots of information on Freedom of Information Law. Every municipality is required to have a Freedom of Information Law policy. You're required to designate one or more record access officers, commonly the town clerk, because the town clerk has a statutory role in records management, both under the town law and another state statute called the Arts and Cultural Affairs Law. The town clerk has an active role in records management. Many records are filed with the town clerk. The town clerk will oversee the records, and so they are often also designated to be the FOIL access officer. You may have more than one designation in that capacity. Maybe you have one for each department, or if you know that there's a particularly busy department, you may have a records access officer designated for just that department. The function of the records access officer is to work with individuals who are looking to access municipal records. Those records are all provided in accordance with state policy and state requirements. You can charge fees, which are also regulated by the state of New York. You are also required to have a record retention policy. This is under the Arts and Cultural Affairs Law. It is a policy that is managed by state archives and promulgated by regulation. The current local government records retention policy is called the LGS 1. And again, every town is required to have a records management policy, and your town clerk by statute is called the records management officer and is there to assist and oversee the proper storage, maintenance, and destruction of records in accordance with the town's policy and the state record retention schedule. If you ever have a question, you can always reach out to our office. We're happy to help you with that. Or if it's a FOIL question, you could reach out to the Committee on Open Government, or a records management question, you can reach out to state archives. I did want to touch upon one thing since we have a little bit of time here. For folks who are new to office, all of the prior office holders were required to leave the town records in place. If you are in need of accessing records that you cannot find, talk to your town clerk first as the records management officer. If they're not available, talk to the former office holder if you can, if that person is still available to you. If they're not aware of where they are, or if needed, if they have them and are not willing to turn them over, there is a proceeding that you can utilize. It's found in Public Officers Law, Section 80. You can have the town attorney draft a demand letter to the prior office holder, which would require them to return any town records that they have in their possession. Sometimes folks don't know that they have them. Sometimes folks think that they're theirs, that it was not really a town-related record. And, there's a need to get them back into the town hall. And if that's not fruitful, there's a court proceeding that you can use to get those records returned. Any record should be maintained unless it is authorized to be destroyed under the state record retention schedule and the town's records management policy. Next slide, Sarah. Miscellaneous administration. Towns are required to provide animal control services. This is a requirement that is found in the another state statute, the Agricultural and Markets Law. It was amended a few years ago to broaden the scope a little bit. So counties can also provide animal control services. Towns can either provide this service by doing so themselves, or the town can do an intermunicipal agreement with other towns or with the county to provide this service. Part of providing this service requires the designation of a dog control officer, sometimes referred to as a dog warden or an animal control officer. The town can appoint its own dog control officer, or the town could contract with a humane society to provide that service on behalf of the town, or the town can do an intermunicipal agreement with other municipalities to share animal control services. The Tug Hill, a shout out to the Tug Hill Commission. There's a great issue paper posted on their website about the new animal shelter regulations. These went on the book. This went on the book, I think in December of 2025. It requires certain rules and regulations for animal shelters, whether that's a shelter that the town itself is sponsoring, another municipality is sponsoring, or a humane society is sponsoring. There are various rules and regulations that now need to be complied with. Those are all there for the care of the animals that are being housed in the shelter. Another service that towns often provide is recreational and park services. Here we're looking at a voluntary service that towns are not required to provide, like animal control services. This is a voluntary service. This is a service the town can provide to its residents in many different ways. It can be a town-wide service. It can be an improvement district service. It can be the ownership and provision of parks, which you can provide, or you can provide recreational services. Maybe that's a pickleball league. Maybe that's jazzercise at the community center. Maybe that's a youth program, a summer camp. There's all different kinds of things that towns can do. Maybe your town holds festivals or concerts or things of that nature, or services for senior citizens. You've got a lot of opportunity. The town can do this either as a service that it provides, or it can contract with a service provider. Maybe your town contracts with various sports leagues to run sports programs for adults or children, or with a senior center to provide services for seniors. Got a lot of opportunity for recreation, but again, those are all voluntary services that the towns can provide but are not required to provide. And now we've got some emergency or essential services. These come into three general buckets: police, fire, and ambulance. Towns have the authority to provide for police departments as a town service, as a town department. They would be funded and regulated and overseen by the town board. About 12% of towns have their own police departments. Alternatively, your town can rely upon the county sheriff or the state troopers to provide law enforcement services. And if you would like enhanced services provided to your community, either by the county sheriff or the state troopers, or perhaps both, you can talk to them about entering into an enhanced service contract where you are contracting with them to provide additional services in your town, in lieu of maybe creating your own police department. Finally, you can do an intermunicipal agreement. It's all about relationships, as Sarah said, and intermunicipal agreements are a great way to provide essential services at a shared or reduced expense to an individual taxpayer. Towns can contract with other police service providers, whether it's another town, city, or village, and you even have the authority to have a joint town-village police department, and some town and villages have actually done that. We talked a little bit about fire service, the importance of fire service. Towns, unlike police, cannot provide fire service as a town service. Instead, it has to be provided through an improvement district, whether that's a fire protection district that is managed by the town board, where the town board contracts with a service provider, whether that's a volunteer fire company or another municipality or a fire district. The town itself is not providing the fire service, but rather is contracting with a service provider on behalf of the residents, businesses, and property owners within the footprint of the fire protection district. And only those individuals would be charged for that service. Or you may have fire districts within your town or that cross town boundaries. As Sarah said, those are regulated and overseen by a separately elected board of fire district commissioners. Finally, we have ambulance service. EMS service is something that we have been talking about and working on. And I know the Tug Hill Commission is very engaged in this space. Towns have a variety of ways in which they can be involved with ambulance service. They can provide it as a town service, similar to police if they would like, or they can own the equipment, but contract with a service provider to manage the equipment, or they can create an ambulance district. So if there's just a portion of the town that needs ambulance service, they can create an ambulance district, like a water district or a sewer district, and then ambulance service is just provided within the district, and that can be done either as a district service or through a contract with a service provider. You can do it through an intermunicipal agreement where several municipalities come together. And right now, there was legislation that was put on the books at the end of December or at the end of 2025, requiring counties to put together a group within each county, including all municipalities within the county, to look at how emergency services are being provided within the county and to come up with a plan to make sure that everybody is having access to that service. It's an important service. Stay tuned. There's going to be, I think, some forthcoming rules and regulations and guidance documents coming out of the Department of Health to help counties with that. So stay tuned. That's an evolving issue.
Hey, Laura, just before I move on to the next slide, I wanted to give a time check that it is 7:28.
That is perfect because I have one slide left, and this is really just more of a public service announcement.
Great.
If you are an elected official, you are required to take and file an oath of office, and you have to do that within 30 days of the commencement of your term. So you just have a day or two left, if you have not already done so, to take and file your oath of office. You need to do so in front of somebody who is authorized to administer an oath. Most commonly, that's going to be your town clerk or maybe your town justice. You're going to go down to the town clerk's office. You're going to sign the oath book, and you want to make sure that you do this before your time expires. The reason that it is super important is because by operation of state law, if you don't do so within the time period provided, which I think it expires January 30th, so you want to make sure you get this done before January 30th, just a day or two left. You vacate your office that you worked so hard to get elected to. And you want to make sure that it's on file with the town clerk's office. So take your oath of office and then go down and sign the town clerk's sign book. Also, if you happen to be and somebody who touches money, the supervisor, the tax collecting officer, there's a list outlined in Town Law Section 25. You need to also be covered by what's called an official undertaking. That's an insurance policy that the town takes out in the event money is lost or stolen. Okay, that covers our oaths, official undertakings, and your bird's eye view of local government in New York State. And so we are now going to pivot and we are going to talk about ethics. We want to get you off on the right foot. You have a basic overview of how towns work, and now we want to make sure to give you the tools that you need to properly provide those services and undertake your offices. And Sarah's going to walk us through the importance of ethics in the next hour.
Yeah. So that's what I'm going to do. I guess before I get started, while Lori was going through her parts of the presentation, I was thinking about the last time that we did this for the Tug Hill, for Tug Hill and the webinar that we gave in 2024. And I don't know, it just struck me that at the time I had really short hair. I had really bad cancer a few years ago, and I lost all of my hair. So I want everybody to know on this webinar that not only are you working with really, really knowledgeable people at NIOT, NICOM, and Tug Hill, you are working with really, really kind, wonderful people. Obviously, I can't say enough about people that I worked with at NIOT and Lori, but Katie and everybody at NICOM was really, really wonderful. So yeah, you're working with the best of the best.
Sarah,
Thank
I
you,
think you're
Sarah.
lovely.
Yeah, so thank you for allowing me this weirdly emotional moment. On that note, we are going to get into municipal ethics. If I talk in terms of towns, which I know that I will, just know that the law is equally applicable to village, county, city level governments. It's the same for everybody. So even though I'm talking in terms of towns, that's just my bread and butter. That's just the parlance in which I speak. Municipal ethics, everybody gets into local government, I think, with the best of intentions. But there are
Sarah, can I interrupt you
situations.
just quickly?
Sure,
You
yeah.
still have the Welcome to New York PowerPoint up. I didn't know if you
Oh,
wanted to pivot to your
wait,
ethics.
no, on my screen it's showing the municipal ethics.
It is? It's not
We're
on
Yeah.
me?
actually, I'm seeing your oath and official undertaking
Oh, really?
slide and notes. Yep.
It's showing, okay, let me try this one. What about now?
There
Yes,
you go.
there you
Okay,
go.
all right, great. I also see. Okay, so yeah, now that I'm on the right, it was showing up on my screen as municipal ethics. So thanks for noting that. Um, I think that people get involved in local government more than any other sort of form of governance, right? More so than at the state level, at the federal level, because you want to do what's right for your community. And you can have the best of intentions and still act in a way that is not in compliance with what municipal ethics require. I doubt that many of you got elected into office or decided to participate in local government because you wanted to screw over your residents and get something for yourself. So today we are going to go over some of the common, really basic level municipal ethics topics, including conflicts of interest in contracts, common law conflicts of interest. By common law, I mean court-created law. Court-created law is something that you have to follow the same level that you would statutory law. So if I say general municipal law, section da 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 says X, Y, and Z, but then I say common law says X, Y, and Z, you're still required to follow common law the same as you would statutory law. It's just that courts have created this law. And I think that you'll see throughout this presentation how many gaps exist in statutory law. Those are statutes, state law that the state legislature has created. Under common law conflicts of interest, we're going to go over some issues with nepotism and family. Dual office holding, that's when one position can hold two different offices. If we're lucky, we're going to get into gifts. But I've given this presentation, this is not my first rodeo. I've given it a number of times. So I'm just going to say spoiler alert here. Don't take bribes. Don't take gifts that can look like bribes. That's really all I have to say about gifts. And then because I'm an attorney, I always like to hedge and say, maybe we'll cover miscellaneous. Some things that we're not going to cover today include the Hatch Act, or your justice, your town or village justice, and your town or village attorney are subject to additional levels of ethical rules. I'm not going to go over that today. We're just going to go over some really basic municipal ethics 101. As I said before, ethics really refer to, you could go into a position and have the best of intentions and still violate ethics rules. We all have our own internal guide that we follow. Some people are religious. Some people worship at Highmark Stadium. I call it Rich Stadium. I'm a Buffalonian by birth. Love it. Right? We all have our own internal guideline of what we think of as appropriate and what we should follow, right? That's not what I mean when I'm talking about municipal ethics. I'm talking about an objective set of rules that that the law says is appropriate and that municipal officials have to follow. And they act not only as a shield, right? The public, it protects the public against avaricious officers acting in their own self-interest, but it also acts, I guess that's a sword, right? It also acts as a shield for public officers who, if you have not experienced this yet, I guarantee you will. You are going to be sitting in a board meeting, in a trustee meeting, and somebody from your community is going to come in to your meeting and say, you are up to something shady. You're up to something nefarious. I don't like what you're doing. It's just wrong. That's going to happen. And should that happen, you are going to be able to point to these objective set of rules and say, in the words of the dude from The Big Lebowski, that's just like your opinion, man. I have followed what I am legally required to do. I have followed my ethical responsibility. But throughout this presentation, I think that you'll see too that reasonable minds can differ, right? It doesn't mean that person A is wrong and person B is right, especially when we get into the grays. I love ethics laws. I love municipal ethics in general because there are so many gray areas. It's one of the reasons why Lori hates it. But there are areas where reasonable minds can differ. Nonetheless, it's important to know how to evaluate things and be able to justify your course of action should you be presented with an ethical issue. What am I talking about when I'm talking about these objective sources of laws? First and foremost, there is General Municipal Law, Article 18. It is, pardon me, the only source of state law on ethics. It is not the best, most comprehensive piece of legislation that has ever existed. And I think throughout this presentation, you'll see where these gaps exist. GML Article 18 hasn't really been substantively changed since the 1980s. There have been proposals before, but there are issues with it. There are gaps that exist. There are some shortcomings. Therefore, we have common law. Again, common law is court-created law. I can't point to a statute and say town law, village law, section 803 says this. I would say, hey, the court has taken a look at this and said X, Y, and Z. Again, you still have to follow it the same as you would statute. But the court has really tried to fill in the gaps that exist in GML Article 18. Also, you have your local ethics code. Under GML Article 18, every municipality is required to have a local ethics code. It is a wonderful opportunity to clarify situations, fill in some of the gaps that exist in GML Article 18, and really flesh out how your municipal officers are supposed to act. Take a look at it. If you haven't already, take a look at your local ethics code. It's a really important document. Agency opinions, by that I mean AG, Attorney General opinions or State Comptroller opinions. Those, unlike common law, are just suggestive. You are not required to follow them. However, they often serve as a really good canary in the mine, right? They're kind of like, oh, here's how a court might rule on it. Also, they're really useful if you have that person who comes into your board meeting and says, haha, the town is up to something really shady. then you can point to an agency opinion and say, you know what, the controller's office, the AG's office has taken a look at this issue and they've determined actually there's not a conflict of interest. Actually, I'm okay here. I love local ethics boards. If you have one, please avail yourself of them. There are, as I mentioned before, a lot of grays in ethics, and a lot of ethics questions are very fact specific. You really have to look at the exact situation to determine a course of action. There's no one size fits all. Lori and I work together. We also have another attorney in the office, Katie, and the three of us will often discuss ethics situations if somebody calls, and the three of us might have slightly different opinions on how somebody should proceed. What I love about ethics boards, it's that it's a meeting of the minds to come up with one conclusion on how an official should proceed. Ethics boards are statutorily advisory in nature. I think one of the frustrating things people encounter with ethics is that it's very self-regulatory. You get to decide for yourself, weighing the consequences and things. Nonetheless, I really like your local ethics boards if you have one available to you. In addition to being an attorney and liking to hedge on everything, other includes talk to your town attorney, call NICOM, call NIOT, talk to your board members, take the temperature of your municipality and see how big of a deal something is. If other officials have encountered a similar situation, a large municipality might have much more strict ethics rules when it comes to the gray areas. Again, there are some areas that are very black and white letter law, right? You should clearly do something or not something. But when you get into the gray areas, your local ethics code might have much more strict rules. Your practice in a municipality might have much more strict rules. The consequences might be much more significant than a neighboring municipality. So talk to other officials in your area, take the temperature of your community, talk to your municipal attorney. I cannot stress that enough. And then, as I mentioned before, of course, you can always call NICOM, NIOT, NISAC if you're with a county. Starting off, in our evaluation of municipal ethics, we're going to take a look at conflict of interests. To evaluate a conflict of interest, I want you to start with three sources and always, always, always start with GML Article 18. I will say this a ton of times. If there is a conflict of interest under GML Article 18, you are not allowed, by you, I mean your municipality is not allowed to enter into the contract. The idea is that the poison, if you will, lies with the contract itself, not with your municipality. Therefore, recusal is insufficient to cure a GML Article 18 conflict of interest. I'm going to say it again and again and again, but recusal is insufficient to cure a GML Article 18 conflict of interest. That's why I always want everybody to start with GML Article 18. If you're like, I don't know, is this a conflict of interest? The second source of authority that I want people to look at is your local ethics code. Again, it's a really outstanding opportunity to fill in some of the gaps that exist in GML Article 18 to further define what is appropriate and how your municipal officials should act. However, there are a lot of circumstances under which your local ethics code doesn't clarify. It doesn't offer exact authority. And then we get into common law. Again, that's court-created law. I'm going to get into why I don't like to call common law conflicts of interest the appearance of impropriety, which some people might have heard of before. But again, just common law, court-created law, but always, always, always start with Article 18 if you're evaluating if there is a conflict of interest. Because if there is, under Article 18, the town, the village simply may not proceed. More so than I think other areas of laws, of municipal law, of law in general, I think ethics law really tends to evoke an emotional response. I am an emotional person. I talk with my hands. I tend to just get overwhelmed with anger, a sense of injustice, whatever, sadness. So I have developed, and I like to use this 6-question series to evaluate if something is ethical or not using these objective standards. It really takes the emotion out of things and kind of puts on my lawyer robot hat, right? Being like, da, 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 yes, no, and removes the emotion from something. So the first question to ask is, does the potential conflict lie with the contract with your municipality? The second question would be, do you have an interest in the contract? If the answer to question number 1 is yes. Question number 3, do you have control over the contract? And these quotation marks are not just random. These are specific definitions, but do you have control over the contract? If yes to questions number 1 through 3, do any statutory exceptions apply? Question number 5, what does your local ethics code say? And question number 6, is there a common law conflict of interest? And don't you worry, I'm going to go through each of these questions extensively. Starting with question number 1, does the potential conflict lie with a contract with your municipality? I don't want you guys to get too hung up on the definition of contract, but I do want you to know that for the purposes of GML Article 18, the definition of contract is really broad. Sometimes we think of contracts in terms of, signing a blood oath, being like Ariel and very specifically signing a document. And we don't necessarily think about going to a grocery store and purchasing something as a contract. But for the purposes of GML Article 18, a contract means a claim, account, demand, agreement. It can be written or oral, express or implied. Again, don't get too caught up in that. Just know that a contract is much more broadly defined than what one might suspect under GML Article 18. One thing that is not considered a contract would be a land use application. So anything appearing before your ZBA, your planning board, that is not a contract. And that makes sense, right? You're not guaranteeing anything in return. But yeah, don't get too caught up. So I like to learn by hypotheticals. The first hypothetical question that I'm going to present to people would be, a town board member hires a planning board member to help prepare their taxes. Is this contract prohibited by GML Article 18? Some of you might be sitting there saying, Sarah, why in the world would I know this? We are, checks notes, a few minutes, 15 minutes into the ethics presentation. How can I answer that? Let's go back to our 6-question analysis. And question number 1 is, does a contract or potential contract lie with the municipality, exist with the municipality? Spoiler alert, even though you are in a municipal office, you are all still normal, regular people. And just because you decided to participate in local government doesn't mean that you are no longer just a resident of your town, just somebody who has friends, family, and you operate in your everyday functions. So here, under this scenario, you have a town board member who is wearing their personal hat. If you think about it in terms of like, I'm wearing my town official hat, I'm wearing my municipal official hat, and I'm wearing my personal hat in my personal capacity. So here we have a town board member wearing their hat as in a personal capacity, working with a planning board member who is also operating wearing their personal hat. There is no contract here that involves the town or your municipality. Therefore, GML Article 18 is not going to exist. If we look at the first question, does a contract or potential contract exist with the town? Question number 2 is, do you have an interest in the contract? An interest is defined under GML Article 18 as as a direct or indirect financial or material benefit received as a result of the contract. I will say courts tend to focus on the direct financial result, but it is a fairly broad definition. But again, interest, material or financial benefit received as a result of the contract. Under GML Article 18, if you have an interest, again, material or financial benefit received as a result of the contract or potential contract, you are considered to have, I think I worded this poorly, but let's say that your spouse has an interest in a contract. You step into the shoes of your spouse. So if your spouse has an interest in a contract, you are considered to have an interest in that contract. If your minor child or dependent has an interest in that contract, you step into the shoes. You are considered to have an interest in that contract. Very specifically, under GML Article 18, it says that contracts of municipal employment are not included in this. The reason why that is important is because if there were not that exception, then two members of the same family might not be able to work for the same municipality. So if your husband, if your wife, if your child is applying for a position of employment, don't worry, they are allowed to do that. And I'm going to get into positions. I'm going to get into issues of family, but GML Article 18 is not going to prohibit members of your family from applying for a job with your municipality where you work. GML Article 18 also says if your firm, partnership, or association where you work or are a member has an interest, you are considered to have an interest. Again, you step into the shoes. Also, a company where you are an officer, director, employee, or stockholder, if they have an interest, you are considered to have that same interest. I'm going to scale that back a lot when I get to statutory exceptions, because some of you might be sitting there thinking to yourself, oh my God, I don't do this full time. I work for X, Y, and Z company. The town, our municipality contracts with them a lot. Are we not allowed? Sarah said that we're not allowed to enter into those contracts. Don't sweat it. I'm going to scale that back when we get to statutory exceptions. However, for now, I just want you guys to get the sense of if my employer has an interest, then I am considered to have an interest in that. GML says that if you have an interest in a contract or a proposed contract, you should disclose that interest in public, in writing, give it to your immediate supervisor or governing board, and you should give that disclosure even if a statutory exception applies. Going on to hypotheticals, let's say that the town wants to build a new town hall. Could the following contracts be covered by GML Article 18? Hypothetical number 1, what about a construction company owned by the supervisor? Let's go through our analysis. Question number 1, is there a contract or a potential contract with the municipality? Yes. Question number 2.
Here's what I found.
Oh my gosh. My watch was just like, hey, Siri, I think I hear you talking. Anyway, and it was like, Sarah, this is your answer. Technology is terrible. Anyway, so question number 1 is there a contract or a potential contract with the municipality? Yes. Does the supervisor have an interest in this contract? Yes, they are going to receive a financial or material benefit as a result of the contract. What about question number 2, or hypothetical number 2, a construction company owned by the adult son of the supervisor? Question number 1, is there a contract or potential contract with a municipality? Yes, definitely. Question number 2, Does the supervisor have an interest in the contract? Again, an interest being a direct or indirect financial or material benefit received as a result of the contract. If you note, going back 2 slides, I said that if your minor child, meaning under 18, has an interest in a contract, you are considered to have an interest in the contract. This is one of the shortcomings of GML Article 18, because in this hypothetical, I specifically say the adult son. Of course, you are going to have to look at things on a case-by-case basis and take a look at the exact facts and circumstances surrounding a situation. But generally speaking, let's say that the adult son lives on their own, the supervisor, it is their company, but it feels wrong, right? It doesn't feel great to say that a supervisor can approve and be engaged in discussion on a contract that is potentially going to their child. GML Article 18 would say, hey, this is cool, don't worry about it. And that is one of the gaps that exist. That's where common law, again, court-created law, is going to fill in the gaps and cover those situations. Question number 3 to ask is, do you have control over the contract? And control under GML Article 18 has a specific definition, and it means that individually or as a board member, you have the authority to negotiate, draft, authorize or approve a contract, authorize payment under a contract, audit bills or claims, or appoint anybody with any of those powers or duties. Again, turning to some hypotheticals to really illustrate that. Let's say that the town is building a new town hall, and I promise you that I am reusing this example for a very specific reason. But let's say the town is building a new town hall. Does GML Article 18 apply to a contract between the town and the town clerk's spouse who owns a construction company? Question number 1. Does a potential contract or contract exist between a municipality? Yes, absolutely. Here we have the town looking at contracting. Question number 2. Does the town clerk have an interest in the contract? Again, interest being a financial or material benefit derived as a result of the contract. I mentioned you step into the shoes of your spouse. So if your spouse has an interest, you are considered to have that same interest. So yes, here the town clerk does have an interest in the contract. Question number 3, does the town clerk have control over the contract? Again, control meaning the ability individually or as a board member to negotiate, draft, authorize, approve, authorize payments, audit bills or claims, or appoint anybody with any of those responsibilities. The town clerk definitely has some pre and post audit responsibilities. Nonetheless, as we went over in the Welcome to Town Government session, it's the town board that audits claims. It's the town board that approves contracts. So in this situation, the town clerk does not have any control, as that term is defined under GML Article 18, over the contract, and therefore the town would be able to proceed and potentially enter into a contract with the town clerk's spouse. Another hypothetical is, let's say the town assessor is also a plumber. Does GML Article 18 prohibit the town from contracting services with the assessor for plumbing services? Question number 1, does a potential conflict lie with a contract or potential contract with the town? Yes. Question number 2, does the assessor have an interest in the contract? Will they potentially receive a direct or indirect benefit as a result of the contract? Yes, they will. Question number 3, does the assessor have control over the contract? And here we are focused on, does the assessor have control when they're wearing their assessor hat? The assessor has no responsibility, no authority over granting contracts, auditing claims, anything like that. Therefore, under GML Article 18, there's no, because there is no issue of control, we would go directly to what does your local ethics code say, but GML Article 18 is not going to prohibit this contract. Question number 4 to ask is, does a statutory exception apply? And General Municipal Law Section 802 has the full list of statutory exceptions. I'm just going to go over some of the most common ones. Number 1 would be pre-existing contracts, but no renewals. By that, I mean, let's say that you have a contract with your municipality to provide road salt. Awesome, great. Maybe you have had such a great experience and you care so much about your community that you have decided to run for public office and you get elected to the board. All right. Let's say that contract runs from October 2025 to May 2026, and you're now elected to the town board as of November of 2025. You join the town board January 1st, 2026. This exception says that, okay, that's cool. The contract is already in place. Because obviously there are issues of there's a contract with a municipality, you absolutely have an interest in it, and as a town board member, you 100% have control over it. You have the authority to audit, approve, all of that. But this exception says, all right, we understand that happens. You can continue the contract until its terms end. And again, in this hypothetical would be May of 2026. Go ahead, continue on, but you cannot renew the contract. You can finish it, but you cannot renew it. I said before that if you hold stock in a company and that company has an interest in a contract, then you are considered to have an interest in that contract. Here's where we get into, I said I was going to scale that back. If you own under 5% of stock in that company, don't sweat it. Your town would still be able, your municipality would still be able to enter into a contract. I like to use, I usually have an empty Diet Coke can or bottle on my desk. I don't tonight, but I love Diet Coke. Let's say that I'm on the town board, right? And I own 6% stock in the Coca-Cola company. I guess the first question I'm going to ask is, what am I doing with my life that I am now involved in local government when I own 6% stock in Coca-Cola? Why aren't I on a beach just enjoying life, not really doing much? Nonetheless, let's say I am on the town board. I own 6% stock in the Coca-Cola company. That means that the town could not purchase any Diet Coke products. If I own 4%, I'm still questioning my life decisions, but at least the town can purchase products from the Coca-Cola company. Contracts under $750 annually, that is kind of a de minimis exception. So if a contract in a fiscal year is under $750, then GML Article 18 says that amount is so small, we're not worried about it. To be clear, that's not a contract that is $749 in January, $749 in February, $749 in March. No, it's $750 in the aggregate over the course of a financial year, in which case, if the contract is that small, GML Article 18 says that a municipality can still enter into that contract, but I'm going to get into common law standards that say you should still recuse yourself. Just know that GML Article 18 is not going to prohibit you from that contract. Contracts with a membership corporation or a voluntary nonprofit corporation or association. I like to think of this as the volunteer firefighter exception. particularly in the Tug Hill region and in the North Country, I found that volunteer firefighters tend to join the town board or municipal board. If this exception did not exist, you would not be allowed to contract with that volunteer fire company for fire protection services. Also, potentially, nobody in your municipality would be able to join the board of a NIOT or a NICOM. So this is an exception to that. Again, I like to think of it in its most simple terms as the volunteer firefighter exception. I said before, if your employer if you have an employer outside of your municipality and they have an interest in a contract, you are considered to have an interest in the contract. And I said that I was going to scale that back pretty significantly. And here's where. So if you are a municipal officer employed by a company, but you do not receive any payment from the contract with your municipality, and you have no part in the procurement, preparing, or performance of that contract, here's where that statutory exception would apply. And a perfect illustration of that would be if a town board member works in an auto parts store where the town highway department sometimes purchases items, and their duties as the employee at the auto parts store do not include the procurement, preparation, or performance of any of the town orders, and they are paid a salary and do not receive any compensation related to the sales to the town, then this is an appropriate statutory exemption. Really, if we're dealing with the employer situation, you want to stay away with the 10-foot pole from anything to do with the contract involving the municipality where you work. And then that statutory exception would apply. However, as we're going to get into, common law standards would probably dictate that you should recuse yourself from voting on anything related to that contract. If you go through your 6-question analysis and you start focusing on questions 1 through 4, which is how you analyze if a GML Article 18 conflict of interest exists, if you have a municipal contract, interest, control, and no statutory exception applies, you do not pass go, you do not collect $200, your municipality is not allowed to enter into the contract. Again, the poison lies with the contract itself. Recusal is insufficient to cure a GML Article 18 conflict of interest. A few notes, because I've been doing this. This is not my first rodeo. I have given this presentation a number of times. Competitive bidding does not cure a GML Article 18 conflict of interest. Emergencies do not cure or excuse a GML conflict of interest. GML Article 18 is a pretty draconian mistress. It is fairly strict. Don't think to yourself, well, our municipality bid out the project, so that should kind of take away the stain. There's nothing in the law that says that that is so. If you have a contract, potential contract, interest, financial or material benefit derived as a result of the contract, control, and no statutory exception applies, the municipality simply cannot enter into that contract. What are the consequences of entering into a contract despite there being a GML Article 18 conflict of interest? Well, a willful violation could result in the contract being considered null and void and payment prohibited. Any willing and knowing violation could result in a misdemeanor. What are the differences between a willful violation and a willful and knowing violation? Because those seem like some pretty stupid lawyer terms, which they are. But a willful violation is nobody's holding a gun to your head. You are willfully entering into a contract. You are not under duress. Willful and knowing is you are not entering into a contract under duress, but you know that you should not be entering into a contract. Potentially, this could result in a misdemeanor conviction. And I do want to bring to people's attention that under Public Officers Law, Section 30, a misdemeanor involving your oath of office results in an automatic vacature. It results in your office being automatically vacated. You don't have to go to court to say, yeah, you're vacated now. But if you are, again, convicted of a misdemeanor involving your oath of office under Public Officers Law, Section 30, your office is considered automatically vacant by matter of law. Some hypotheticals, again, to really flesh this out. Let's say that a supervisor owns a flood service company and there is a really big storm in the town and the town hall starts to flood. If this continues, then the town is going to incur substantial damages, like there's going to be hundreds of thousands of dollars worth of damages to the town hall. And the town supervisor owns this business that happens to be the only one in town, the only one available that can deal with this in a timely manner. And the supervisor is like, you know what, this is great. I'm going to save the town hundreds of thousands of dollars because I'm going to address this with my business immediately. Excellent. I'm saving money. We're doing great by the taxpayers. Is this contract prohibited by GML Article 18? Maybe you can tell by the look on my face. Question number 1, is there a contract or a potential contract with the town? Yes. Again, remember that contract is really broadly defined. It doesn't have to be in writing. Question number 2, does the supervisor have an interest in the contract? Yep, they could potentially receive a financial or material benefit as a result of the contract. Question number 3, does the supervisor have control over the contract? Yep, as supervisor, they have the authority to audit, negotiate, authorize the contract, all of that stuff. Question number 4, does a statutory exemption apply? Here, this is a real life example. I actually had a supervisor call and ask me this question. And my response to him was, how much were the services worth that you provided? And he said about I'll just say more than $750. And I said, well, would you be willing to take $749? Because again, emergencies do not they're not an exception to GML Article 18. However, contracts in the fiscal year under $750 annually would qualify as an exception. It's a perfect example of a situation where somebody really truly believes that they are doing the right thing. However, the law says that you have to act in a specific manner. So ultimately, my advice was accept $749 and recuse yourself from any sort of auditing of those claims. Another hypothetical, which again, I promise serves a purpose. The town is building a new town hall. Let's say the town wants to contract with a construction company. The construction company has a separate subcontract with a steel supply company that is owned by the town supervisor. Is this prohibited by GML Article 18? And I want to make sure that everybody understands the construct here. We've got the town supervisor, or the town wants to contract with a construction company. The construction company has a contract with a steel supply company, and the steel supply company is owned by the town supervisor. Question number 1, does a potential conflict lie with a contract with the town? GML Article 18 is only concerned about the contract that exists between the town and the construction company. It does not care about the contract that exists between the construction company and any sort of other vendor. Some people might be sitting there saying, this doesn't feel right, this doesn't feel good. And again, that is where we get into general municipal law or common law conflicts of interest. Once we go through our GML Article 18 analysis, and let's say that there are no conflicts of interest, cool, great. The municipality can enter into the contract, but you still have to take a look and see at what your local ethics code says. I can't tell you what your local ethics code says, right? So you're going to have to go back and take a look at it yourself. But then the sixth question to ask is there a common law conflict of interest? A common law conflict of interest is sometimes referred to as an appearance of impropriety. I don't like this phrase. I hope that you will see why, but it stems from a case from 1979. And in there, a court took a look at a situation and said, okay, you didn't violate GML Article 18, but we think that you violated the policy of the law. So even though technically you didn't violate any statute, government officials must maintain confidence in the integrity of government. They must avoid even the appearance of impropriety. The test to be applied is not whether there is a conflict, but whether there might be. It is the policy of the law to keep the official so far from temptation as to ensure his or her unselfish devotion to the public interest. I don't like this language. I don't really think it's potential. It's like particularly instructive. How do you apply this? Like the question is to ask not whether there is a conflict, but whether there might hypothetically someday be. I and many others have taken a look at case law as it has developed since 1979. And that's why I don't like the term appearance of impropriety. Also, a common law conflict of interest doesn't just apply to contracts. GML Article 18 conflicts of interest are very narrow to contracts. And I said before that a land use application is not considered a contract, but when we go into the realm of common law conflicts of interest, land use applications absolutely apply. So it is a much broader category. This is my PowerPoint opus magnus opus, right? The greatest piece of art that I've ever produced on a PowerPoint, where we've got the larger circle, which is common law conflicts of interest, again, encompassing land use applications and any activity of a municipal official. And then GML Article 18 really only covers that small subset involving contracts. So again, going back to the language that's in the 1979 case about the appearance of impropriety, that the test to be applied is whether there might be potentially someday, hypothetically, a conflict of interest. I like to break it down into two very practical questions. Number one, is the interest personal? And number two, is the interest substantial? The first question, is the interest personal, is a lot easier to evaluate. And a personal interest is not one that you share with the public generally. It has to be really unique and really specific to you. A good example of this would be, let's say that you're on the town board, you live within a water district. Presumably that water district is not a parcel of one that you live on. You share, like many other parcels of property are within that water district. So that's not an interest that is very specific and unique to you. That's an interest that you share with many other people, and therefore you would still be allowed to vote on things like sewer rents, any sort of maintenance and upgrades to that sewer district. Question number two, is the interest substantial? Is a lot more nuanced question. A really good example of this would be my absolute favorite case of all time, and it involves a planning board chair who owned a steel supply company. And there was an applicant that was appearing before the planning board. The applicant appearing before the planning board had a contract with the steel supply company for supplies. Somebody litigated and said that, hey, you know what? We actually think that the planning board chair should have recused himself because they had this contract with the applicant appearing before the planning board. So again, let's just like understand the construct here. We've got the planning board chair. An applicant is appearing before the planning board. The applicant has a contract with a steel supply company, and that steel supply company is owned by the planning board chair. This is why I kept going over the town wants to build a new the town wants to build a new town hall scenario. Just kind of setting up that construct, right? Because we're dealing with a land use application, we are automatically not within the realm of GML Article 18. So question number 1, is there a contract or potential contract with a municipality? No, because we're dealing with land use applications. And as I said before, land use applications are not under the purview of GML Article 18. So is the interest personal? Yeah, this is pretty specific and unique to the planning board chair. Is the interest substantial? The ethics board took a look at this situation and said, hey, you know what? The contract amounted to only 0.15% of the company's gross sales over the last 2 years. We don't think that that is substantial enough to impact the planning board chair's ability to remain impartial. Somebody wrote to the Attorney General's office. The Attorney General's office cited the language that I quoted earlier about the appearance of impropriety standard, and they were like, it is the policy of the law to have such unselfish devotion, blah, blah, blah. The test to be applied is not whether there is, but whether there might be. It went to the Supreme Court, which is the trial level court in New York State. And the trial level court said, you know what, we're going to agree with the AG's office. It went to the appellate division, and the appellate division said, first and foremost, that Sarah left out some very critical pieces of information, and that is, what does 0.15% of gross sales over 2 years actually equal? What does that amount to? Well, in this circumstance, it amounted to $2,000. And the court said, in this very specific circumstance, given the facts presented before us, we do not think that this is a substantial enough interest to impact the impartiality of the planning board chair. This is a case that I love so much because it really highlights how, number one, facts, the circumstances surrounding a scenario really inform how somebody should proceed. The court didn't say, hey, well, you know what? If it were $3,000, then we would think it's too much. Let's say that is 0.15% of the Coca-Cola company's proceeds over the last 2 years. That might look like a lot more money, and that might tip the scales a little bit more towards a court finding that there was a substantial enough interest. But in this case, the court said, hey, you know what? Given the circumstances, we don't think that this is substantial enough. I also love this case because I think it perfectly encapsulates the idea of reasonable minds can differ. It's not that the ethics board was right and the appellate division was right and the AG was wrong and the trial court was wrong. It's just that the buck stopped with the appellate division. And some of you might disagree with the determination that the appellate division made. And that's cool. That's okay. But I do think that this perfectly illustrates some of the gray areas that exist and how substantial can be an amorphous, not exactly defined term under the law. Also, when we're talking about substantial, this is where we get into the issues of relationships and how close you are to people. So the neighbor of a planning board member it's not the fact that they're a neighbor that might disqualify a planning board member from acting on an application of their neighbor. You really have to take a look at the facts and circumstances. What is the relationship that somebody has with their neighbor? Some of you might be more antisocial, like myself, And just know that your neighbor exists. They live a mile down the road. You know that their lawn is mowed. Cool, great, okay. That tends to lend itself more towards, there's not a substantial relationship there. Other people, your neighbor might be your best friend. You regularly hang out. That might lend itself more towards, maybe I should consider recusing myself. And recusal is ultimately going to be a personal decision. Your ethics code can further define when recusal is necessary, in which case you have to follow that. But otherwise, like, there is no definition of recusal and what that entails. It's a very fact-specific and individual determination. Another way that I like to think of substantial is the interest more than speculative? Is it more than, well, this might happen someday, maybe if X, Y, and Z happens? And is it more than really minimal? This is also, when we're thinking about substantial, this is also where we get into ideas of family, and there's no nepotism law in New York. Your local ethics code might have a nepotism law that applies, but otherwise there is no nepotism rule in New York. However, under common law standards, you should generally not participate in decisions concerning the salary and terms and conditions of employment for a fellow family member who is also employed by a municipality. A perfect example of this would be, and this is more common than one might think, let's say that a wife is on the town board and their husband is the highway superintendent. Under GML Article 18, I mentioned before, there is this exception for members of the same family working for the same municipality. Some families are just born into public service. Totally cool. The law allows that. However, under common law standards, that would say that interest is personal, right? It is unique, specific to that individual, and it is substantial enough. Obviously, they are married. It is going to be substantial enough. Some of you, and so common law would say that you can vote generally on general highway matters like the purchase of equipment, but you should not vote on specific things that are specific to your individual family member, such as salary and the terms and conditions. I am checking the time. That is 8:28, and I know that we are supposed to end at 8:30. Here's just an example of some language that might exist in your local ethics code with respect to nepotism. This just says that you have to disclose the fact if a family member is applying for a position in your municipality. And I just wanted to highlight the second hypothetical here. We have Carrie is on the town board. Her long-term boyfriend, Kent, applies to be on the zoning board of appeals. What should Carrie do? Under this example policy language, you are only required to disclose if somebody is related closer in degree by blood or by marriage than first cousin, anybody who is seeking employment within the town. And in this hypothetical, we have Carrie and her long-term boyfriend. Technically, the ethics policy here is not going to apply. They are not related closer in degree by blood or by marriage. I specifically said long-term boyfriend, they're maybe living in sin, right? But common law standards would still say, Carrie, that is a personal, unique interest. It is substantial enough. Carrie has been dating Kent for a long time. It's substantial enough. Carrie should recuse herself. And then it is a good practice to disclose that interest. Just some things to keep in mind if you were going to recuse yourself, that recusal is always going to be the equivalent of a nay vote. Recusal should be removing yourself from influencing the process altogether, removing yourself from discussion. There is no state definition of what constitutes recusal. Your local ethics code is a really good opportunity to further define what's required under recusal. And by recusal is always going to have the functional equivalent of a nay vote. By that, I mean, let's say that you have a 5-person board. 2 people vote yes, 2 people vote no, and 1 person recuses themselves. That vote is never going to be counted as a yay. That's never going to be counted as a yes. That is always going to be counted as a nay vote. I am going to end because we're at 8:30. I'm just going to go like 2 minutes over and go really quickly over when one person can hold 2 different positions in a municipality. And generally that's cool. That's okay. However, there are 3 different circumstances under which 2 people or 1 person cannot hold 2 different positions. One is if there's an issue of subordination. That means that position A cannot be the boss of position B. Circumstance number 2 would be if there is a conflict of duties. I like to think of that as if you are upsetting a system of checks and balances, if you are reviewing your own work, or if the duties in position A and duties in position B are so inherently at odds that nobody reasonable would think that one person can do both jobs, then that would be a conflict of duties. Situation number 3 is pretty easy to identify, and that is otherwise prohibited by law. That means if there is a statutory prohibition. For example, Town Law Section 20 says that 1 person may not hold 2 elected offices in the town. Town Law Section 271 says that a town board member may not also hold a position on a planning board. So state law says in some situations. I'm going to end. This is my second to last slide. If you've ever seen a presentation by me before, you know that I am A, from Buffalo originally, and B, an unabashed cat lady. This picture is here on purpose. This is overcoming incompatibility, where I have my 2 late cats. I could not bring myself to remove this picture from this presentation. My ladies recently passed away in 2025 after a very long, fruitful, wonderful life. But here they are superseding, they're overcoming an incompatibility. And the AG's office says that if you are in a small municipality, if it is in the public's interest, you can overcome that incompatibility by local law. That means, let's say there's a situation where somebody was the dog control officer and they did an amazing job at it, and then they got elected to the town board. You live in a small municipality. There's an issue of subordination there. The town board has the authority to set the salary and appoint somebody to the position of dog control office. So position A is essentially the boss of position B. You're in a small municipality. Here's my recommendation. Advertise for the position of dog control officer. Either nobody's going to apply or nobody qualified is going to apply. Advertise for the position again. The same thing is going to happen. Again, this is just my advice. This is not required under the law, but I think it's a good way of establishing that this is in the public interest. So advertise for the position again. Either nobody is going to apply or nobody qualified is going to apply. And then, pursuant to this AG opinion, your municipality could adopt a local law saying, hey, it is in the best interest of the municipality to overcome this incompatibility of office so that 1 person can hold both the position of dog control officer and town board member. So that way, when that gadfly attends your town board, your village trustee meeting and says, the town is up to something really shady. I think that you're doing something nefarious. I think that you're doing something weird and unethical. You can say, hey, we've taken a look at this. It is in the best interest of our municipality. And I said that that would be my second to last slide because I did want to end on, I did recently adopt 2 cats to my tigers, so I wanted to end introducing my new cats. And I know that we are at 8:35. Katie, if you want, I'm happy to stick around for questions, but if you wanted to end it, that's cool too.
Yeah, thank you so much. That's a ton of information and very, very interesting. I've heard your presentation a couple times now, and I always pick something new out of it. The chat has been pretty quiet, so I'm going to say if anybody's got something they want to put in the chat, now is the time. They're probably all kind of like deer in headlights, like, wow, that was a lot, and I need to process that for a few minutes. I see some thank yous in the chat. I'm not seeing any questions. Um, Both Sarah and Lori have indicated that they're very willing to answer questions. I would encourage, all of our towns to become members of NIAT. They're a great resource, and you can call them up and use their website resources. We are we have them on speed dial. So looks like there's just a lot of thank yous. So I think we can let everyone go. Whoa.
Oh, sorry.
Sorry.
I
That's
did not
okay.
mean to do that. My bad.
That's okay. So everyone have a safe, well, you know what? It's a good thing we didn't do this in person because it would have been canceled. So everyone's hopefully home. You ladies look like you might be still at the office, but hopefully it's not too bad where you are. Um, thanks again.
As a native Buffalonian, no, there's no snow here.
We will
I
see you
beg to
guys.
differ.
Beg to differ. We have a question. Is there an inherent conflict of interest for a planning board member to also be a realtor with local interest?
Yeah, so actually that's a great question. And there definitely are circumstances where there are a ton of AG and controllers' opinions that address the realtor land use board situation. And there are absolutely situations where one should recuse themselves. If you have like a more specific situation, and I'm very happy to send those opinions out. But yes, I guess as like a general high level answer is there are 100% situations where you would need to recuse yourself if you are on the planning board and you are also a realtor.
All right, good to know. Good question, Rebecca. Thank you. Thank you, Sarah, for the kind words. So I'm going to stop recording. This video will be up on our YouTube hopefully tomorrow, and we'll have slide deck from NIAT, and we will email that out to everyone in the next few days. So thanks again, and have a good night, everyone.
Thanks, Katie.